Good afternoon, everyone. Thank you for joining us today for our online talk, which will be starting shortly at 3 p.m. For those of you who are here early, thank you for waiting patiently. While you're waiting, we would like to share with you a short video from the firm.
I founded the firm in September 1985 with the vision of seeking truth and justice for our clients and not just winning their cases. Over the years, the team has achieved many significant milestones. We are today recognized by the Legal 500, Asia Law Profiles, and Asian Legal Business as a recommended firm in various practice areas. While we have embraced technology to make our services efficient and responsive, we continue to grow on a bedrock of meticulous preparation and hard work, for which there is really no substitute. As legal practice becomes increasingly international, we keep ourselves ahead of the curve with our relationships with lawyers from around the world. Our firm is a founding member of the League of Lawyers, a growing international network of law firms in 20 Asian and European countries.
We believe in partnering with our clients to protect and grow their business. We achieve this by holding firm to our values of integrity and justice, while giving our best to deliver effective and efficient solutions. Instead of just legal services, we focus on developing great working relationships based on understanding and respect.
We regularly advise foreign clients, including many Chinese investors, and have a ready appreciation for different ways of doing business. In corporate matters, we offer relevant and commercial solutions, often raising issues that clients may or may not have realized before. In negotiations, we believe in facilitating win-win outcomes.
Welcome, everybody. Thank you for joining us for today's online talk entitled The Federal Court's Decision in Obata-Ambak Holdings, Its Impact on Developers and Purchasers. My name is Amanda Ponmeisu, and I'm an associate with Ma Weng Kwai and Associates, and I will be a moderator for today's session. Before we start today, let me introduce the firm and what we do. Associates is a mid-sized law firm that was founded in 1985 by our Datuk Ma Weng Kwai. Our able team today comprises of 37 lawyers and a support team of 28 of us. Datuk Ma today is a consultant with the firm, following his retirement from the Court of Appeal bench in 2015. The firm continues its tradition today of working primarily with SMEs, family businesses, and also individuals. We are a full-service law firm with a corporate department, a dispute resolution department, including litigation, adjudication, and arbitration, a dedicated employment, industrial relations team, and a department focused on servicing the needs of individuals and families. And next, our practice groups in the firm indicate some of our focus areas, which are supported by talents from both our corporate and dispute resolutions teams. Today's talk is part of our MWKA online talk series. By way of background, we have been organizing monthly lunch talks at our office since 2013, and some of which were broadcasted live. But with the COVID-19 MCO, we have moved online in order to continue with our objectives of sharing knowledge, raising awareness, and encouraging networking for clients, potential clients, and in-house counsel. Before I continue, please be reminded that this talk does not constitute legal advice, but in the event you require specific legal advice to your matter, please contact us for a complimentary legal consultation, and details of which we will provide at the end of this talk. And for today's talk, we have two speakers. First, allow me to introduce Ms. Denise Phang. She is a partner of this firm, and she is in the Dispute Resolution Department. And the second speaker we will have today is Wong Chee. He is a senior associate in our Dispute Resolution Department. And let me introduce the talk points for today's talk. First, we will start with the introduction to the relevant act, and next we will go on to Ang Ming Lee's case, as well as the problem arising from that decision in that case, which will be both covered by Mr. Wong Chee. And we will carry on with the next 2 points on the federal court's decision in Obata's matter, as well as its wider implication of that case. And those 2 points will be covered by Ms. Denise Phang. And we will also conclude the talk at the end with a Q&A session where you can raise all of your questions if there's any. And so if you have any questions, please don't forget to type it up in the chat and we will address them at the end. Now let me pass the floor to Mr. Wong Chee to begin our talk for today.
Thank you, Amanda. Good afternoon, everyone. So for the purposes of today's talk, where we will talk about the case of Ang Ming Lee as well as the recent decision of Obata, we believe that we would first need to talk about the Act itself, which is the Housing Development Control and Licensing Act 1966, as well as the Regulation 89. I will cover this point as well as what the case is about, what Ang Ming Lee is about, and what are the problems arising from Ang Ming Lee. So first, we look at the Act, Housing Development Act, or what we usually call it as the HDA. So what does it cover? What does it entail? So HDA, if you look at the Act, the preamble of the Act actually covers it or states very succinctly what it covers. So it provides for the control and licensing of housing development business in Peninsular Malaysia, as well as the protection of interests of purchasers. So this would basically, the Act would basically cover licensing of the developers. For those audiences here who are from the developer companies, you would be very familiar with this, and also the provisions in the Act as well. The Act also covers duties of the developers in terms of getting license, and the Act also covers offenses. I'll go through very briefly the overview of the Act in a bit. So just to give an overview again, so this Act is basically administered by the Ministry of Housing and Local Government, or the Kementerian Perumahan and Kerajaan Tempatan, or what we usually call it as KPKT. And this Act is very important because it ensures that the housing developments in Peninsular Malaysia must be carried out by licensed housing developers. I'm sure many people, especially in Klang Valley, involved in, or you are staying in condominiums, you would have to be aware of this area, this topic. Now, going into the Act, what I have done right here is basically I have split it into two sections. The first one is certain provisions which I think are relevant to the developers. I'm sure the developers would be very familiar with these sections. So, for example, maybe Section 5 is prohibition against housing development except by virtue of license and provisions relating to a grant of license. So basically, the section talks about the requirement for housing developers to basically have a license. If you do not have license, you will not be able to undertake a project, for example. So that would be Section 5. Section 7 covers basically the duties of a licensed housing developer. Just giving some examples right here, as stated in the Act. For example, developers will need to submit certain documents to the controller. They will need to exhibit, you will need to appoint auditors, for example, and so on and so forth. There are quite an extensive list of duties that the developers would have to adhere to. Now, Section 13 is revocation and suspension of license. I don't think I need to talk about too much in detail about that. So basically, the ministry has the powers to revoke or suspend the license of the developers. Section 16, which is something that might be useful for developers to know, which is any decision by the minister, the developers would have the right to appeal to the minister against the decision of the controller. For a lot of times, dealing with KPKT, it will be, if you look at the documents, the letters, it will be, a lot of times you will see letters issued by controller, for example. So developers do have that right to appeal to the minister. Section 19 and 21, it covers offenses by housing developers. Briefly, it is just stating out what are the offenses and what is the penalty if you fail to comply with the provisions of the Act. So that would be provisions concerning developers. Now, going to certain provisions which concern home buyers or purchasers. I'm not sure if any of the audience here are potential home buyers, or if you are home buyers yourself or purchasers of any property under HDA. So these are certain provisions which are relevant to you, which you might want to be aware of. Section 16 basically covers the tribunal for home buyer claims. So if you can see here, Section 16L, a home buyer may commence a claim with the tribunal to claim for any loss suffered or any matter concerning his interest as a home buyer. So this basically means that if you have any losses suffered, even if it is a liquidated accident damages claim, like late delivery of vacant possession, this is something that you can go to the tribunal to claim against the developer. Section 16M basically says that the jurisdiction of the tribunal is only up to 50,000. It doesn't exceed 50 ringgit claim. So naturally, if it exceeds 50,000, then it doesn't fall under the tribunal. Where you would have to go is you would have to file a claim in court to maybe say, for example, claim for liquidated damages. Section 16N sets out the jurisdiction of the tribunal, which states very clearly that the tribunal has no jurisdiction for claims on recovery of land, any estate or interest in land, or disputes on entitlement of any person under a will or settlement. So these areas would have to be, if you have any disputes mentioned here, so you would have to go to the courts to resolve these kind of disputes. And one more is Section 16AC, basically says that the decisions of tribunal is final. Now, I do want to also bring your attention to this Section 24 for the purposes of today's talk. Basically, this section states that the power to make regulation for the purposes of carrying into effect the provisions of this Act. So if you can see here, in the second point here, Section 24 sub 2, there are a list of powers that the minister has, list of items that the minister has power to make regulations. I would just focus on Section 24 sub 2 sub C as well as sub 2 sub E. So the minister has the power to, say, for example, prescribe the form of contracts which shall be used by the developer, his agent, nominee, or purchaser, both as a condition of grant of a license under this Act. And E would be regulate and prohibit the condition and terms of any contract between a licensed housing developer, his agent, or nominee. Now, moving on to this Regulation 1989, which will be very relevant to the cases that we will talk about in a bit. There are actually a few regulations, but for the purposes of today's talk, we will just focus on Regulation 89. Just an overview of the regulations here. Regulation 3 would be application for a license. Regulation 4 would be renewal of housing developers license. 5 would be advertisement and sale permits. And this is the important one that we will focus on, which is Regulation 11, contract of sale. So this is like the standard form of contract in Schedule G and H. So Schedule G is basically housing accommodation with subdivisional portion of land appurtenant, basically property with connecting land. So that will fall under Schedule G. Schedule H is the typical condominium projects, where that would be housing accommodation with subdivided building. That would fall under Schedule H. There is a standard form of contract that is provided under the regulation. Regulation 11 sub 3 states that where the controller is satisfied that owing to special circumstances or hardship or necessity, compliance with any of the provisions in the contract of sale is impracticable or unnecessary, he may, by certificate in writing, waive or modify such provisions, provided that no such waiver or modification shall be approved if such application is made after the expiry of the time stipulated. So basically, this regulation, in short, what it's saying is that controller under this regulation has the power to waive or modify any of the provisions. Now, I have here with me the link to the standard form of contract. I think for the purposes of the audience here listening in, I will just maybe show you very quickly how it looks if you have not seen one, especially potential purchasers or home buyers. So this is just very briefly, this is the standard form of Schedule H of the standard form of contract. So it basically sets out the standard terms, schedule of payments, loans, interest, as well as, I think the more important one would definitely be the delivery time for delivery of vacant possession, if you can see, as you can see here, for Schedule H, the time for delivery of vacant possession is 36 months. Now, Schedule G would be 24 months, if you can see in section 23 here. Yeah, so it says 24 months. So this is just a sample of the standard form of contract under Schedule G and H. We will now go into the case of Ang Ming Lee. This is decided by the Federal Court in 2020. But before we go into what the Federal Court has decided, let us just give you some overview of this case, what this case is about. So I have set out here the brief facts of the case. Sir entered into SPA to purchase several units in 2012. So this SPA stipulated that the delivery of vacant possession shall be 36 months from the date of signing of the respective SPAs. Now, 2 years down the line, the developer found that was facing a lot of issues with the completion of the project. So the developer applied for an extension of time of 12 months to deliver vacant possession of the units to the purchasers. If I recall correctly, the extension of time application filed by the developer, they were citing reasons such as residents nearby complaining about the noise, working after the normal working hours. There was stop work order issued by local authorities, and there was some investigation conducted on the piling contractors. So these are just a few reasons why they were applying for an extension of time. After they have submitted their application, the controller initially it got rejected, and naturally the developer filed an appeal. If you recall, I mentioned just now, Section 16 allows the developer to file an appeal if you are not satisfied with the decision of the controller. So this is what the developer did. They have appealed against the decision of the controller, and after hearing the appeal, the minister allowed the application. So now the time for delivery of vacant possession changed from 36 months to 48 months. And then in 2015, November, it was allowed, where this letter was signed by this person, Jaya Seelan, on behalf of the controller. So this is actually the letter that approved the application or allowed the appeal. So the purchasers, obviously, they would feel aggrieved about this decision because in the SPA it says 36 months, and because the developers couldn't complete in time, they went to file for an extension of time and it was allowed, and then they had to wait for another 12 months. So the purchasers filed judicial review application against the minister, the controller, as well as the developer. So in the High Court allowed the purchasers judicial review application and ordered the decision to be quashed. Of course, the developers were not happy with this decision. The developers went to appeal against the High Court's decision. Now, in the Court of Appeal, what the Court of Appeal held was that the Regulation 11 sub 3, as I have shown earlier in my slides, is not ultra vires the Act. So what is ultra vires? Basically, ultra vires means goes beyond the Act. So what the Court of Appeal basically says here is that this regulation allowing a controller to make or modify any such provision, it doesn't go beyond what is stated in the Act. The Court of Appeal went on to say that the controller has wide powers under the Act. The Court of Appeal also said that the letter that basically allowed the appeal, signed by this person, Jaya Seelan, was invalid and has no effect. The order in the letter was made without jurisdiction. The court did make the finding that the purchasers were not given an opportunity to be heard prior to any decision made on the extension of time. So both parties now appealed again to the Federal Court, and I have extracted the certain extracts from the grounds of judgment. Here you can see in paragraph 36, the Federal Court held that the wordings in paragraph 24 sub 2 sub E, it should be given a strict construction in the sense that the minister is expected to apply his own mind and not to delegate that responsibility to the controller. Now, paragraph 40 is quite often cited by a lot of judges in subsequent cases. It says that the Act, being a social legislation, is designed to protect the house buyers. Interests of purchasers shall be paramount consideration against the developer. So paragraph 60, the Federal Court held that controller has no power to waive or modify any provision in Schedule H contract of sale because Section 24 does not confer the power on the minister to make regulations for the purposes of delegating the power to waive or modify any provision in Schedule H contract of sale. So or modify the Schedule H contract to the controller. What it means is basically saying that the Act does not give the minister the power to make regulations and to delegate this power to waive or modify Schedule H of contract of sale to the controller. So the controller essentially, if you can see the last few lines here, Regulation 11 sub 3, conferring power on the controller to waive and modify the terms and conditions of the contract is ultra vires the Act. So it goes beyond what is provided in the HDA. The Federal Court then went on to say that the letter that I have been talking about just now, the letter by this person, J.R. Sealan, is not a valid letter granting an extension of time to the developer. And if you can just focus on the part where I have highlighted the fact that the letter was signed on behalf of the controller to convey a decision under Regulation 11, in our view, it made it crystal clear that the decision to grant the extension of time to the developer was that of the controller and not the minister. So essentially what the Federal Court has decided is that Regulation 11 sub 3 goes beyond what is stated in the Act, and the controller does not have the power to basically modify what is provided under Schedule H of the contract, which is to amend, say, for example, in this case, 36 months to 48 months. Now, after this case was decided in 2020, there were a lot of issues, I would say, in the courts where the Federal Court in Ang Ming Lee did not expressly pronounce whether this ruling, the ruling that Regulation 11 sub 3 is ultra vires the Act, is to be applied retrospectively or prospectively, meaning to say it's not clear as to whether this ruling it will be applied after this decision or it applies blanket, provide it applies to all. So now, what happens to cases where the EOT was granted by the controller to developers under Regulation 11 sub 3 prior to the decision of Ang Ming Lee? So these are the cases that was subsequently filed in courts where, if you can see here, the aftermath of Ang Ming Lee, we will see numerous claims filed by purchasers against developers in the court for LAD following the Ang Ming Lee case. So a lot of the purchasers were suing the developers and citing Ang Ming Lee as grounds to say that their extension of time was ultra vires the Act, and the controller did not have the power to do that. These are usually claims where the EOT was granted before the decision of Ang Ming Lee. So even in courts, there were very different and conflicting decisions in the Malaysian courts. We would see some cases following Ang Ming Lee, some of the judges trying to distinguish or trying to depart from Ang Ming Lee. And we were also seeing cases such as purchasers filing a claim against developers many years after the vacant possession was delivered. And what the purchasers were saying is that the LAD should be computed from the expiry of 36 months. Bearing in mind that some of these cases, the purchasers have actually gotten some compensation from the developers already. I think later my co-speaker Denise will also touch on this in the Obata case, where it has similar facts, where the purchasers actually got some LAD from the developers, but they still proceeded to sue the developers after the expiry of 36 months. So now we were seeing a lot of issues here, and developers were forced to pay LAD to purchasers to prevent further claims by purchasers, notwithstanding that they actually complied with the procedure for the EOT application. So because of all this confusion, much clarity is needed. This is where the Federal Court case of Obata comes in, where I will now pass on to my co-speaker Denise to talk about the case of Obata. Denise, over to you.
Thank you, Chien. Hello, ladies and gentlemen. Thank you for joining us this afternoon. Following from my colleague Chien, I will now be talking about the Federal Court's decision in Obata and how that was the continuation of the Ang Ming Lee saga. Now, just before I go into Obata, just to put in perspective what Chien has touched on Ang Ming Lee. Ang Ming Lee actually put the entire construction industry into a whole frenzy. Ang Ming Lee was decided in 2020. At that time, there was also the pandemic, but there was also this decision where at the time, prior to 2020, all extensions of time was actually granted by the controller based on the regulation. So the minister had no part to play in it. Then suddenly when Ang Ming Lee, the Federal Court said, okay, controller, you cannot approve extensions of time because you have no power. The power lies with the minister. So the minister is the one who approved, you cannot approve. But at the time in 2020, there were already construction projects ongoing that relied on various extensions granted by the controller. So in one sense, so when the extensions of time was held to be invalid, purchasers started to file suits in court. So challenging their SPAs where it's no longer the standard term of 24 months or 36 months. Some extensions have been granted for 48 months, 54 months. Some even the extensions has been granted, even though the SPA has stated that it's 36 months, the controller gave an extension subsequent to the SPA, which extended the completion date. So those were all being challenged in court, and basically all the purchasers were claiming for LAD, and developers were in a panic because paying out that high of amount of LAD could potentially actually bankrupt the developer, which is why then cases started to move up within 4 years in High Court of Appeal and Federal Court, which is why we have this case of Obata-Ambak Holdings Sdn Bhd against Prema Bonanza Sdn Bhd and other appeals. So technically in this case, there are actually 3 cases. Obata-Ambak Holdings was one purchaser. Prema Bonanza was the developer. So briefly, Prema Bonanza, the developer, actually applied for EOT to amend the terms of the SPA. So instead of the 36 months under Schedule H, they asked for an extension to 54 months. And this was because there are various reasons given. The works need a longer time and etc. So therefore, and in this extension was granted by the housing controller in December 2010. So the dates are very important. You look at the dates, 2010. Before the execution of the SPA, controller granted an additional 2 years. So 36 months became 54 months. Then Obata started selling their property. And in this case, Prema Bonanza started selling, and Obata purchased 3 units in 2012 and 2013. So at the end of the day, Prema Bonanza was late in delivering vacant possession, and they actually did settle. Prema Bonanza, the developer, actually paid Obata a certain sum as settlement to settle the LAD. So both parties were actually, the LAD settlement sum was actually paid out to Obata. Subsequently, because of Ang Ming Lee in 2020, Obata then filed a suit against Prema Bonanza at the High Court for additional LAD. It was like, oh no, previously we calculated LAD on 54 months. So now I don't want to calculate LAD based on your completion date of 54 months. I want to calculate LAD based on the completion date or completion period of 36 months. That will be an additional 18 months of LAD. So Obata filed a summary judgment application. Prema Bonanza filed an Order 14A application, which is basically also a summary judgment, but based on interpretation of the law. So in these cases actually involve interpretation of the law or the contractual clauses, so they don't need to go for trial. After hearing the case, the High Court allowed Prema Bonanza, the developer's application, and dismissed the purchaser's application. So the High Court said this: Ang Ming Lee is binding, but at the time the development was launched, the SPA was signed in 2012 and 2013, Ang Ming Lee was not decided yet. So Ang Ming Lee was decided in 2020. So at that time, in 2020, the developer had already obtained EOT from the housing controller. In fact, when Prema Bonanza signed the SPA in 2012 and 2013, it's already stated clearly in the SPA that it is 54 months, not 36 months. So therefore, the High Court held in favor of the developer. They said that Obata's suit was actually, although Obata was claiming for LAD, they are essentially actually claiming or challenging the validity of the EOT, which was granted to Obata. And this was granted 8 years ago. So therefore, Obata filing this suit is actually improper. And because they filed this suit 8 years later, Obata's claim is time-barred. In Malaysia, in order to commence a civil suit, you must commence a suit within 6 years. So because it's 8 years already, the court held that it's time-barred, the court will not hear Obata's claim. So that was the High Court's decision. Obata appealed to the Court of Appeal, and the Court of Appeal also agreed with the High Court, dismissed Obata's appeal. So Court of Appeal said that, yes, they are challenging with the validity of Clause 25 and 27. And that cause of action runs from the date of execution of the SPA, which is 2012, 2013. High Court and Court of Appeal in Obata are in agreement. So the problem that arises is, concurrently, another suit was filed at the High Court. This is the case of Vignesh Naidu. Same development, same developer, different purchaser. So this purchaser is called Vignesh Naidu. So Vignesh Naidu signed his SPA again also similarly, July 2012. And he claimed that the SPA signed was 54 months and not 36 months, therefore invalid. It was extended. The extension is invalid. He wants LAD calculated based on the 36 months completion date. So there will be an additional 18 months of LAD. The High Court initially allowed the developer's application to strike out the claim. But here in Vignesh Naidu, they appealed to the Court of Appeal. The Court of Appeal here, that's the most contentious part. The Court of Appeal agreed with Vignesh Naidu's arguments. And then they applied Ang Ming Lee's decision to say that, oh, the Court of Appeal is bound by Ang Ming Lee because Ang Ming Lee is a federal court decision. Following the Ang Ming Lee, the controller had no power to give EOT. EOT is invalid. You cannot agree that the EOT is legitimate. You cannot waive legitimacy of Regulation 11 sub 3 because parties have no powers to do that under the law. Therefore, Vignesh Naidu, the purchaser, claim for LAD can be calculated from the date of acceptance of their cause of action, Their cause of action arose from the date of acceptance of the delivery of vacant possession, not when they signed the SPA. So instead of going back 8 years, the court said their cause of action only accrued when the vacant possession was delivered. So therefore, they could sue for LAD, and because the EOT was invalid, they can get back LAD based on the 36 months construction period. Now, there are two conflicting Court of Appeal decisions, one in Obata and the other one in Vignesh Naidu. These two Court of Appeal decisions went up on appeal to the federal courts, which is why we have the federal court decision in Obata today. Concurrently, there is also a third suit, Sri Damansara Sdn Bhd. In this case, they were filing an action, or the purchasers in Sri Damansara filed an action against the developer, Sri Damansara. So in this case, the SPA says that vacant possession is to be delivered within 42 months. Also different from the 36 months, this is actually just 6 months extension. And on the 41st month, Sri Damansara actually delivered vacant possession already. So Sri Damansara was within the extended completion period. But nonetheless, the purchasers filed a claim at the Homebuyers Tribunal, and they further calculated LAD from the date of part payment. This is pursuant to another case called PJD Regency. So at that time, previously, the practice was to accept booking fees. So in PJD Regency, the courts held that calculation of LAD can be calculated from the date you paid your booking fee, which is why here, purchasers filed a claim at the Homebuyers Tribunal. And this was the date that they paid the booking fee was actually 5 months before they filed the SPA. If you calculate, there's an additional 11 months of it. The tribunal allowed the purchaser's claim, and then the developer brought an appeal at the High Court. And the High Court allowed the developer's application, but the High Court also held that they were bound by Ang Ming Lee's decision. So therefore, the court have to take cognizance your extension is illegal. Therefore, the purchaser is allowed to claim for LAD after 36 months. Now, again, Sri Damansara appealed to the Court of Appeal. Purchasers also filed a cross appeal. The Court of Appeal unanimously dismissed both appeals and held that they are bound by Ang Ming Lee. The High Court was correct in considering that the extension was invalid. So now before the federal court, there are 3 cases, Obata, Vignesh Naidu, and Sri Damansara. So now the federal court held that Ang Ming Lee's, the facts in Ang Ming Lee, the factual circumstances of Ang Ming Lee is actually very different from the case and can be distinguished, which means it's not the same case from case and Vignesh Naidu and Sri Damansara. So in Ang Ming Lee, the SPA said clearly that it's 36 months. That is the period of construction. But the EOT was granted only after the SPA was signed. However, in Obata and Vignesh Naidu, the EOT was granted before the SPA was signed. So this is very important because when the purchasers signed the SPA in Obata and Vignesh Naidu, in the case of Prema Bonanza, is clearly stated there 54 months. Whereas in Ang Ming Lee's case, what the purchaser signed was 36 months. So this is the first distinguishing factor. So based on that, the court said in Obata and Vignesh Naidu, it's basically a challenge of the previous extension which was granted before the SPA was signed. So therefore, the cause of action must have accrued from the date of the execution of the SPA. The date where you signed, you already knew that it was 54 months. You should have challenged it then. And it doesn't accrue from the date of delivery of vacant possession. So this is the Court of Appeal's decision in Vignesh Naidu was overturned. The judgment is laid down here. You guys can have a look, but I won't go through it in detail. Another issue of law that the federal court held was the second actor theory. So this is more for Sri Damansara's case. In Sri Damansara, the developer who relied on the controller's decision. So the developer is saying that I didn't know that the controller was not supposed to grant EOTs. I relied on the controller's decision. So actually, why am I being asked to pay additional LAD? Why am I being penalized when I relied on the controller's decision or the minister's controller's decision, and they made the mistake, not me? Why should I be penalized? So at the federal court held that notwithstanding, although the extension was unlawful, yes, following Ang Ming Lee, controller cannot grant EOT, but because the developer was, so basically the controller was the first actor who made the mistake. So then Sri Damansara is the second actor. So then they said they are not departing from Ang Ming Lee, they are not revisiting Ang Ming Lee, but this second actor theory would apply so as to not adversely affect the parties who had relied on the decision of the first actor. Because this will cause substantial injustice if the act of the developer is found to be void because of the invalid first act by the controller. So this is what the federal court held for Sri Damansara's appeal. Now, because when the federal court also actually clarified a very important principle for Ang Ming Lee's case. So in this case, it was not stated whether or not this new invalidation of the extension of time is to be applied prospectively, which means for cases in the future, or retrospectively, which means it also applies to cases which were previously decided or previously, for example, SPAs that were previously entered into. So the federal court actually clarified that this Ang Ming Lee's decision should be applied prospectively, which means SPAs that were entered before Ang Ming Lee was decided, which is the year 2020, SPAs which were entered before 2020, Ang Ming Lee's decision does not apply, which means the controller's extension of time pre-2020 is good, okay, even though it's invalid, but the invalidation now will only start from SPAs that were entered after 2020. So the federal court went into the ramification of the entire construction industry, because if you allow Ang Ming Lee to have retrospective effect, to be fair, the developers did not know that extensions could not be granted by the controller. So they are, in the sense, also affected. And if the developers are in the midst of paying out LAD, if this continues to be allowed, developers might be wound up. The construction industry in Malaysia might come to a standstill. The economy might go down. So these are actually serious ramifications which the federal courts considered, which is why then they clarified that Ang Ming Lee should be applied prospectively. So another issue is that the federal court said that there is actually an issue of unjust enrichments. These purchasers, they knew what they were signing. In Obata and Vignesh Naidu, they knew that when they signed, they were agreeable to 54 months of a period of completion. So for them to now take advantage of Ang Ming Lee's case and to come back to court to claim for LAD between the period of 36 months to 54 months, that actually amounts to unjust enrichment. So these are the federal court's decision. It's a very long judgment, so we've provided some excerpts that you guys can go through. So that is the federal court's decision in Obata. Now, this federal court's decision in Obata is currently being applied to cases that are coming, new claims for LAD that are coming into court. For example, this is a newspaper report on The Age, which is actually reported on the 25th of October, which is actually just 4 days ago. Court dismisses buyer's claim for LAD in Bangi housing project, applying prospectively Ang Ming Lee's decision. So courts are no longer allowing claims for LAD. They're narrowing down basically the claims for LAD. So not all purchasers can claim for LAD. How can they claim? Okay, so these are the wider implications of Obata's case. Developers nowadays what developers tend to do, obtain EOT before the signing of SPA, which is what was done in Obata and Vignesh Naidu, and this time obtain the minister's approval for the EOT. So when Ang Ming Lee is applied retrospectively, so developers will not be liable for LAD for periods between 36 months and the extended period of time, provided that VP is delivered within that extended period. So for example, if let's say your SPA says 54 months and the developer still hands over vacant possession late, let's say for even 60 months. So you are still entitled to the purchasers are still entitled to 6 months of LAD in that circumstances. So it's a very limited circumstances, but the EOTs are no longer considered invalid. For purchasers, when you sign the SPA, it is important to take a look at section 23 to see what is the period of completion. Of course, there is Schedule G and Schedule H, which says 24 months and 36 months. But nowadays, developers can apply for an extension prior to the SPAs and get an extension. And the terms, the period of completion under section 23 will be amended. So it might say 54 months or even 60 months. So if you're not agreeable for such a long period of completion, my advice is don't sign, don't buy, okay? But if you do sign the SPA, take note that you're bound by that clause and that you have to allow the developer 60 months, for example, to complete the construction of your property. Another avenue that the purchasers can consider is filing an application for judicial review to challenge the minister or controller's decision. So now no more controller. I think it's very risky for controllers to grant extension of time. It's minister. So if the minister grants the developer an extension of time, if you want to challenge that, you have to initiate judicial review within 3 months. So judicial review, the timing is actually very short, 3 months. It's designed to allow you to act quick. If you think that the authority's decision, that in this case, the government, the Minister of Housing, their decision is wrong, you have to challenge it within 3 months. Cannot wait for 6 years, for example, in civil suits. By that time, the minister would have to, because the minister is actually a public officer, they execute public functions. So in order to, judicial review proceedings is designed to review the public officer's decision, public authority's decision within a short period of time. So if you want to challenge the extension, do it within 3 months. You cannot now only take, after you take vacant possession, then only you come and say, oh no, they shouldn't have granted the extension of time in the first place. So that's not to be done. Following Obata's case, current cases are being disposed by court. Previously, cases that we've handled were claims. We've actually represented both developers and purchasers. So for developers' cases, we have actually, in those cases, applied for a stay of those cases of the purchasers' claims pending the decision in Obata. So once Obata is now decided by the federal court and has been clarified, the high court cases of purchasers' claims are disposed of accordingly. So in one of our clients, who is a developer, who was facing claims against purchasers, their extension of time was more similar to Obata and Vignesh Naidu's cases. They applied for extension prior to the SPA. So therefore, in those cases, the purchaser, after Obata's case, actually withdrew their claims. Now, some of you might ask that before the federal court came out with Obata's decision, some developers have actually also, and some purchasers has brought claims, and some developers has also actually paid, and the high court maybe have the court have maybe decided in favor of the purchaser, and the developer has paid out. So then purchasers will come to me and ask, so can the developer take the money back? And then developers will come and ask me, so can we actually claw back the money from the purchasers, the monies which we have already paid? So the answer to that is, if you had a pending appeal, then maybe. But if you did not appeal and the matter ended there, then too bad, the case ended that way. And this was before Obata's case was decided, that those cases fall under those circumstances. There is a possible avenue to apply for a review of those decisions, but it's unlikely to be granted. At that juncture, your solicitor should have, like what we did, applied for a stay of those cases pending Obata's federal court decision. So if you did it like we did, then the status quo was maintained. But unfortunately, if the case was decided and disposed before Obata's the case came in and Ang Ming Lee's case was applied, then I'm so sorry, developers can't claim back for your monies and purchasers can't get to keep basically the LAD that was claimed. So that concludes my session for today. I'll pass it back to Amanda for the Q&A session. Thank you.
Thank you, Denise and Chee for your excellent insights on the Federal Court decision in Obata-Ambak Holdings. So now we will move on to the Q&A session. We have a couple of questions from the audience. The first question that we have is from Catherine Lee. And this question, I think, can be handled by Mr. Chee. The question reads, does this act cover Sabah and Sarawak? This act would be the Housing Development Control and Licensing Act 1966.
I think I've covered earlier just now in my slides. This act actually covers only Peninsular Malaysia. I would also want to highlight that under Section 1, Sub 3 of the Act, it specifically or expressly states that it applies only in Peninsular Malaysia. I believe the Sabah and Sarawak, they have their own regulation. I think in the Sabah's one, it's called the Housing Development Control and Licensing Enactment 1978. Sarawak's one is called the Housing Development Control and Licensing Ordinance 2013. To answer your question again, HDA does not cover Sabah and Sarawak.
Okay, thank you, Chee. The next question would be from an anonymous attendee, and the question reads, if the decision made by the tribunal is final, if party is not satisfied with the decision, thus the party can file the matter to the High Court. Is it considered an appeal or a judicial review? I think Chee can also answer with this.
Yeah, I'll take this question. Yes, the wordings itself, it says that the decision of the tribunal is final, but you have correctly pointed out that you can still challenge the decision of the tribunal by way of a judicial review. It will not be an appeal. It is basically filing an application in the High Court to revisit the decision of the tribunal. And it's not an appeal, it is to review the decision of the tribunal. So yes, it is a judicial review application, which is very much relevant in this kind of cases, as Denise pointed out, where if you are challenging the decision of the ministry, for example, then you would need to file a judicial review application.
Thank you, Chee. Okay, so now the next question is also by Ms. Catherine Lee. Okay, the question reads, Obata and Vignesh timelines are similar. The court decisions differ. So I would think that, Denise, do you want to take this question?
Yeah, sure. I can actually just clarify this a bit. Like I said, Obata, Vignesh Naidu, same developer, different purchases. And it happened actually concurrently. Not even similar, it's concurrent at the same time. Which is why you have the cases that are filed into the High Court. But actually, even though it's the same High Court, but there are different judges deciding on these cases. So Obata's judge decided in favor of Obata. Vignesh Naidu also in the High Court decided in favor of the developer. When then the purchasers in both cases appealed to the Court of Appeal, again, although it's the same Court of Appeal, but the appeals are heard before different panels. So different judges have different views, which is why you have the conflicting Court of Appeal decisions. So in Obata, the Court of Appeal held in favor of the developer, but in Vignesh Naidu, the Court of Appeal held in favor of the purchaser.
Yeah, I just want to add on for Obata, before the federal court's decision, we have also represented our client in relying on these cases. Back then, when it was still in the Court of Appeal, for the developers would follow or would rely on the case of Obata because Obata favors the developer, because the High Court and also the Court of Appeal in Obata held that the purchasers were actually challenging the validity of the amendment of the clauses. So that is why it was time barred in the Obata case. Whereas in Vignesh Naidu, what the High Court and Court of Appeal held was that the cause of action actually occurred only after the vacant possession has been delivered. So they were still within time. So you see the different, the conflicting decisions there. And now we do have a clarity after the federal court's decision.
Thank you, Denise and Chee. Okay, so now I will move on to the next question. This is from Rosalind Low. LAD starts counting from the booking date or the SPA date?
I'll take that question. So previously, like I mentioned, the Regency's case, which is also actually a federal court case. I think I said Court of Appeal, I don't know, but it's actually a federal court. In that case, the federal court held that LAD can be counted from the date of where you receive part payment. So that was PJD Regency, which is actually the booking fee. But in this Obata's case, the federal court again actually looked at the SPA and said LAD starts from the date of SPA, not the booking fee, not part payment, but SPA. Because if you read Schedule G and Schedule H correctly, the terms literally say from the date of this agreement, which is actually the date of the SPA. When we are looking at both federal court decision, PJD Regency, and also the more recent Obata's federal court's decision in Obata, we would normally follow the more recent decision in Obata. Of course, the future cases might take this, but I think for application of the law, we would refer to the most recent federal court decision.
Thank you, Denise. Okay, I will proceed to the next question. We have a couple more left. The next one is from Mr. Hanizam. What supporting documents are needed for obtaining an extension of time before signing the SPA?
So it depends on, sorry, I think just take this question real quick. Maybe Chee can add on later if you have anything to add. Depends on whether you are the developer or the purchaser. Developer, of course, you have to, now, after Obata, if you need an extension, our advice is to apply before the SPA is signed. So you have to put in an application in writing via letter to the Minister of Housing. And then you have to get the minister's approval in writing, in a letter. So that basically is a letter approving your application and it's signed by the minister. So that means you successfully gotten your EOT. So in your SPA, you can amend your terms to reflect the extended period of completion, the new completion date.
I don't think the purchasers will be asking for EOT. But
before you sign SPA, if you want, but when you see the SPA is not 36 months, the standard 24 or 36 months, you can actually request and clarify with the developer whether or not they indeed gotten the extension.
Yeah, but I just want to touch on this. I think if I'm reading the question again, it does is asking what sort of supporting documents are needed. I think if, say, for example, I'm assuming you are from the developers, we are standing on the developer's point of view, you want to apply for an EOT. Of course, it depends on what are the issues you're facing, whether, for example, if you have limited working hours or the local authority has restricted your working hours to, or maybe shorten your working hours, then, and as opposed to when you started the project, when you say, for example, if you have 12 hours and halfway through the construction of the project, it is reduced to maybe 9 hours. So these are supporting documents that you can rely on. Or of course, if you have issues with excavation, or if you have any issues with the neighboring residents, I think I mentioned earlier in the case of Ang Ming Lee also, these are certain reasons that the developers actually rely on. They say that they have faced issues where the residents are complaining about the noise, so they have to reduce the working hours. They have issues with the excavation, this sort of thing. So you need to have these sort of documents to support your application for EOT.
Perhaps I may add also what Jian said is correct. Some other applications for EOT that I've seen is that, for example, if you need additional time to do your piling and etc. because of the conditions of the soil and etc. Or because, so you do need to adduce your soil investigation report. So that would be your supporting document. Or if, let's say, for example, when you applied for the development, your planning permission, the authorities impose certain additional conditions and to comply with your EIA report, in your EIA report, their assessment, there is something that additional conditions that you need to comply with, and that takes an additionally more time, then you have to also enclose your EIA report and your town planner's report as well as supporting documents. I think that would help the minister come to a more informed decision on the EOT application.
Okay, thank you, Denise and Chee. We have a few minutes left. We still have a couple of questions, but I think I will just pick one out of the few. This is from Soon Peng. The question reads, since the Act only applies in Peninsula, does Obata case law apply in Sabah and Sarawak?
I believe that these two cases are specifically dealing with the HDA as well as the regulation. So I don't really think that it would be helpful if it is to be applied to any situations in Sabah and Sarawak. And I also mentioned earlier just now, there is a specific regulation or ordinance for Sabah and Sarawak. So I would think that, I'm not too sure whether the wordings are similar, but I would not think that this case, the ruling of this case would be helpful to any of the cases in Sabah and Sarawak.
Okay, thank you, Chee. I apologize that we cannot have addressed the next few questions due to our lack of time, but now we have a couple of announcements for you. Okay, so before we conclude, I have a few announcements to make, but first of all, I want to say thank you to Denise and also Chee for giving an excellent insight on this difficult matter that has been popular among purchasers and also developers this few years. So now there's a few announcements that we would like to make on behalf of the firm. We have our upcoming talk, which will take place on the 13th of November, 2024, entitled Managing Misconduct in the Workplace. And also, we would like to also appreciate if you could follow us on our social media accounts. We're on YouTube, Twitter, Instagram, LinkedIn, and also Facebook. And secondly, we would appreciate if you could fill up our feedback form, which is in this. We will be posting it into the chat, the link, and as well as if you would appreciate or you would prefer to have a short consultation with any of our lawyers, we actually offer a complimentary 30-minute consultation over the telephone or over video conference. So you could fill in the form on our website, or the link will also be posted in the chat box. And to all our guests, thank you for joining us today. We hope you found today's session informative and also useful. Thank you, everybody, and see you at our next talk.